A contractor submits a payment claim. The works are late. The principal wants liquidated damages deducted, but the contractor has also lodged an extension of time claim that has not yet been assessed. This is a common scenario in New South Wales construction projects, and getting the sequencing wrong carries serious legal and financial consequences. Here are 6 key points every superintendent, contract administrator, and principal needs to understand. First, the SOPA payment schedule deadline does not wait for the contractual EOT assessment period. Under the Building and Construction Industry Security of Payment Act, 1999, the respondent must serve a compliant payment schedule within the statutory timeframe, regardless of how much time the contract allows to assess an extension of time claim. If no payment schedule is served on time, the respondent becomes liable to pay the full claimed amount as a statutory debt. Second, assess the pending EOT claim on the material available before applying liquidated damages in the payment schedule. A provisional assessment made on the evidence then at hand is far safer than deferring the issue. Identify what evidence exists, request any missing particulars immediately, and grant, reject, or partly allow time with clear reasons before finalizing the scheduled amount. Third, avoid blanket or holding rejections of EOT claims. In a SOPA adjudication, the adjudicator will scrutinize whether the liquidated damages deduction is supported by the contract, the delay evidence, and the reasons stated in the payment schedule. Generic denials or unexplained rejections leave the deduction vulnerable to being disallowed or substantially reduced. Fourth, map the liquidated damages deduction directly to the EOT assessment. The payment schedule must show the adjusted date for practical completion, the period of culpable delay, and how the daily liquidated damages rate produces the deduction claimed. That reasoning chain must be visible in the schedule itself, not reconstructed after the fact. Fifth, the statutory obligation to serve the payment schedule rests with the respondent, usually the principal, even if the superintendent or contract administrator prepares the assessment. It is the principal who becomes liable under Section 14 if the schedule is missed. That chain of responsibility matters when allocating tasks and reviewing consultancy agreements. Sixth, a missed or defective payment schedule may create professional liability risk for the superintendent or consultant responsible for managing the process. If that failure causes the principal to lose the ability to deduct liquidated damages, the principal may allege breach of contract, breach of duty, or professional negligence. Proportionate liability principles and professional indemnity insurance coverage should not be assumed. Both may be affected by the terms of the consultancy agreement. If you are inside a payment schedule period with an unresolved EOT claim, do not wait. Contact Merlo Law for urgent advice.